Good morning, all of you. Today, I have taken up the topic of interplay of provisions of GST law and insolvency and bankruptcy code. The points that I have taken up for discussion for today's meeting are recovery of tax dues prior to the commencement of the corporate insolvency resolution process and the order of priority of dues to the government under tax laws, and whether appeal proceedings can be continued, whether it can be commenced during CIRP period and during liquidation, and regarding commencement and continuation of adjudication proceedings again during CIRP and liquidation, and certain other matters such as whether registration can be cancelled for the tax dues prior to the CIRP period, and whether registration can be cancelled for any tax dues during the CIRP period, and regarding input tax credit, the questions surrounding the eligibility of input tax credit for the corporate debtor in respect of the tax dues which have been extinguished under the approved resolution plan, and also for the recipients of the goods and services from the corporate debtor prior to the CIRP period in respect of the tax dues which have been extinguished. And some of the questions that my group members have added regarding whether the resolution professional has to file a final return, whether he has to apply for cancellation of registration, whether he is liable for the tax dues of the CIRP period, and some other questions have been included in my discussion. I will just give a broad overview of the Insolvency and Bankruptcy Code. The objective of implementing the Insolvency and Bankruptcy Code was that prior to its implementation, there were several laws which dealt with reorganization as well as the insolvency of the companies and also the individuals. Proceedings were initiated under multiple laws under different forum, and there was uncertainty for the creditors regarding the amount that they will be able to recover. And the litigation at different forum resulted in a prolonged delay in the completion of the process, which diluted the value of the business, and all the stakeholders really did not receive anything much after the conclusion of the process. Hence, the government implemented the Insolvency and Bankruptcy Code with the objective of consolidating and also the amending the laws regarding the reorganization in insolvency resolution. The objective was to expedite the insolvency resolution to preserve the value of assets of the business of such persons who are undergoing the process, to promote entrepreneurship and to improve the availability of credit in the system, and also more importantly, it wanted to alter the priority of payment of dues to the government. It wanted to take into account the interest of all the stakeholders. So the Insolvency and Bankruptcy Code contains an express provision under section 238. I will read out this section as it is a very important section. The provisions of this code shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any such law. Most of the taxation laws have taken into account this overriding provision of IBC in the IBC code, and in the GST law in section 82, it contains a provision that notwithstanding anything contrary to contained in any other law, save as otherwise provided in IBC, any amount payable by a taxable person shall be a first charge on the property of such person. When does this CIRP process gets triggered? When there is a default by a corporate debtor, and mainly giving reference to the corporate insolvency resolution process. The provisions of the IBC have been notified to the extent it is applicable for the corporate debtors and for the personal guarantors to the corporate debtors. It has not yet been notified for partnership firms and individuals. So, the reference in my today's presentation is regarding the corporate debtor. So, corporate debtor includes a company and also an LLP. When there is a financial default by a corporate debtor for an amount not less than 1 crore, then an application can be filed with the National Company Law Tribunal for initiating the corporate insolvency resolution proceedings of the corporate debtor. Such an application can be filed by a financial creditor or an operational creditor or the corporate debtor itself. Once an application is made, NCLT is the adjudicating authority under IBC for corporate debtors. NCLT takes up the application and passes an order either accepting the application or rejecting it. Once NCLT passes an order accepting the application, the corporate insolvency resolution process commences. So when NCLT accepts the application for initiation of CIRP, simultaneously, it also appoints an interim resolution professional, directs issue of an advertisement, making a public announcement of the commencement of corporate insolvency resolution process, and also declares a moratorium under Section 14. Section 14, again I am reading out a verbatim from the section, says subject to provisions of subsection 2 and 3 on the insolvency commencement date, adjudicating authority shall by order declare moratorium for prohibiting all of the following. The first two clauses are more important for our discussion. First is institution of suits or continuation of pending suits or proceedings against a corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority, transferring, encumbering, alienating or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. This moratorium commences from the date of commencement of the CIRP process and it will be in place till the conclusion of the CIRP process. The court provides a time limit of 180 days, which can be extended on application, but the outer time limit for conclusion of process is 330 days. So why is this moratorium being imposed? Basically to keep the assets of the corporate debtor and to facilitate an orderly completion of the process, and also to curtail parallel proceedings taking place and to enable the corporate debtor to focus on its resolution plan and to give it an opportunity to continue as a going concern. The first point for discussion is whether the department can recover the GST dues of the pre-CIRP period from the corporate debtor once CIRP commences. Section 14 clearly contains a prohibition for institution as well as continuation of suits or proceeding. It prohibits any proceeding as well as a suit being continued against a corporate debtor. Hence, irrespective of whether the tax liability of the pre-CIRP period has become final or whether it is still in the appeal proceedings, the department cannot initiate recovery proceedings. The department money has to, the interim resolution professional will call for submission of claims by all parties, and the department has to submit the claim with the resolution professional. Is recovery of tax from the corporate debtor, is it a legal proceeding? Is it a suit or a legal proceeding? In the Supreme Court, in the case of Sundaresh Bhatt and Sundaresh Bhatt, liquidator of ABG Shipyard, the questions which were placed before the Supreme Court for consideration in this case was Customs had initiated a recovery proceedings in respect of goods kept in the bonded warehouse where the time limit for keeping the goods in the bonded warehouse had expired. It wanted to appropriate the goods towards a customs duty. So Supreme Court, while considering whether the Customs Department can initiate recovery proceedings when the company was under liquidation, made the observation that non-payment of customs duty, issuing notice for non-payment of customs duty is coming within the ambit of initiating legal proceedings. So in the CIRP period, the moratorium covers both initiation as well as continuation of suits or any proceeding, and no recovery can be made by the department during CIRP period for the pre-CIRP tax dues. The department also in the circular has acknowledged that no recovery proceedings can be initiated, and it also contains instructions to the GST authorities to collect information regarding the tax dues from the corporate debtor and to file a claim. It is very important for the department to submit the claim of the amount that it claims as due to it along with the supporting document within the period which is prescribed under the IBC. So even though in the advertisement calling for submission of claims, a period of 14 days may be mentioned, even the delayed submission of claim during CIRP process is accepted provided the claim is submitted before issue of request for calling for resolution plan has been issued. Since when the resolution professional invites resolution plans to be submitted, he also provides an information memorandum outlining the state of affairs of the corporate debtor. It is important that all the liabilities, crystallized and contingent, are part of the information memorandum for the resolution applicant to submit a plan. So if the claim is submitted by the department after the resolution professional has called for submission of resolution applications, that will be a belated claim and it will not be accepted. So what is the consequence if the department fails to submit the claim or if the claim is submitted beyond the accepted period? When there is a resolution plan which is approved, this due of the government will not be considered in the resolution plan, and later the government cannot try to recover it from the successful resolution applicant. As section 31 of the IBC expressly provides that the resolution plan shall be binding on the corporate debtor, its employees, members, creditors, including the central government, any state government or any local authority. So this has been upheld by the Supreme Court also in Ghanshyam Mishra, where it has held that on the date of approval of resolution plan, all the claims which are not part of the resolution plan shall stand extinguished, and no person can initiate or continue any proceeding in respect of that claim after the approval of the resolution plan. This completes my slide on whether recovery proceedings can be initiated during the CIRP period. So Venu yesterday raised some questions regarding if the GST department had already attached the bank account and recovered some amount, what happens to that? So in my opinion, if the amount has been recovered from the bank account before admission of the CIRP plan by NCLT, that is an event which has taken place prior to the moratorium coming into effect. That can be appropriated by the government. But if the event happens after the moratorium commences, that cannot be adjusted unilaterally by the department towards the tax demand, and it has to form part of the resolution plan. And another question that he had raised was the department had sent communication to the third persons directing them to pay any amount that they owe to the corporate debtor to the department towards the tax dues from the corporate debtor. So what is the action that has to be taken in such a situation? If prior to the payment by the third parties to the department, the moratorium has come into effect, they can always write to the department, bringing to its attention the fact that moratorium under IPC is in effect, and the proceedings of the department recovery proceedings cannot continue. But then an application can be made to NCLT asking for its directions to discontinue the recovery proceedings which has been initiated prior to the CIRP commencement. Any views on this?
Madam, what are the permutation combination? You have to make one table and say yes, no, what I should do. Notice before IRP appointed, adjudication during process, demand confirmed after. Notice during, demand confirmed after. Notice after for demand period prior. Leah, make one table, then we will know what to discuss.
Okay. So for this recovery, I have not made the table. For the subsequent slide on whether appeal proceedings and adjudication proceedings can be initiated, after a lot of discussion, I summarized it in a table for clarity.
Rainbow papers, what happened?
I will come to that, sir.
Okay, proceed.
So now I covered the point on whether recovery proceedings can be initiated or continued during the CIRP period. I concluded saying it cannot continue and the department has to submit the claim. So the department claim will be considered in the resolution plan. The resolution applicants, they will make a proposal, and typically, obviously, all the dues of the corporate debtor will not be taken over by the resolution applicant. If the amount outstanding by the corporate debtor is X, he will always come up with infusion of X minus Y. Since the funds available, which is being brought in by the resolution applicant, will be less than the dues of the corporate debtor, we have to look at what is the priority of the dues of the corporate debtor. What is the priority in distribution of the money that is available for distribution? IBC, under IBC, the dues to the government is included in the definition of operational debt, and hence any dues to the government under the taxation law, it will become an operational creditor. And the definition of secured creditor under IBC is a creditor in favor of whom security interest is created. And there is a definition for security interest, which says security interest means right, title, or interest or claim to a property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation. And the second part of the definition of security interest says and includes mortgage, charge, hypothecation, assignment, or any other agreement or arrangement securing payment or performance of any obligation of any person. And transaction is also defined as security interest is defined to mean a right, title, or interest created by a transaction. Transaction is defined in an inclusive manner to say transaction includes an agreement and arrangement in writing for transfer of assets or funds, goods, or services from or to the corporate debtor. Section 53 of IBC provides for the priority of dues of the corporate debtor for settling in case of liquidation. The first priority is the insolvency resolution process cost and the liquidation cost. And the second will be workman's dues for a period of 24 months preceding the liquidation commencement date, and debts to secured creditors who have relinquished their security interest. That is the second bucket. And the third bucket will be wages and unpaid dues to employees other than workmen for a period of 12 months prior to liquidation commencement date. Fourth in the queue is the financial debts owed to unsecured creditors. And the fifth bucket is dues to the government in respect of whole or any part of the period of 2 years preceding the liquidation commencement date, and debts to secured creditors for the amount which remains unpaid after they have enforced their security interest. So the dues to the government comes fifth in the list, and it is only for a period of 2 years preceding the liquidation commencement date, which is coming in the fifth list. After that comes any remaining debts and dues, and then the preference shareholders and equity shareholders. Though section 53 talks about the order of priority in the event of liquidation, this is equally relevant in the case of insolvency resolution process also, as under section 32 for evaluating whether a resolution plan which has been submitted meets the conditions laid down in the IBC. One of the conditions is the resolution plan should provide for payment to the operational creditors of an amount which they would have received in a liquidation process. Hence, we had to factor in the order of priority laid down in section 53 both for the CIRP process as well as liquidation. The Supreme Court in Rainbow Papers, it held in this case was in the context of Gujarat VAT Act, and whether the provisions of Gujarat VAT Act provides a security interest to the VAT department, and whether the VAT dues will be treated as dues to secured creditor. The Supreme Court in para 55 it observed that it overruled the decision of NCLAT, and it said that section 53 says that notwithstanding anything to the contrary, the process shall be distributed in the following order of priority. And section 48 is not contrary or inconsistent. And so by the operation of Gujarat VAT Act, the VAT department becomes a secured creditor and the dues to the VAT department becomes a secured debt, coming first in the order of priority. The review petition against this Rainbow Papers was also rejected by the Supreme Court. In another judgment of Supreme Court in Paschim Anchal, they did not agree with the decision of a coordinate bench in Rainbow Papers, and they said Rainbow Papers did not notice the waterfall mechanism. And based on the observations of the Supreme Court in this decision, a review petition was filed before the Supreme Court for Rainbow Papers. And Supreme Court in the order on the application for review said we have considered the provisions of section 53 and it rejected on technical grounds saying it cannot review its own decision. How far the decision of the Supreme Court in Rainbow Papers has been followed under other tax laws, central excise, customs and GST law? The other court, they have made a distinction between the provisions of Gujarat VAT Act and other taxation laws. And they have said that the provision in, say, Central Excise Act regarding a creation of interest, charge on the assets to be the first charge is not pari materia with the provisions of GVAT. So, National Company Law Appellate Tribunal in the Central Excise decision, when it held that government dues will be an operational debt and not a secured creditor, it said that from the usage of the words save as otherwise, save as provided in section 11E, it is in the nature of exception intended to exclude the class of cases. So this is the way in which it distinguished the decision of the Supreme Court in Rainbow Papers. So I have a table comparing the provisions of Gujarat VAT Act, Central Excise Act and CGST Act. Gujarat VAT Act says, notwithstanding anything to the contrary contained in any law for the time being in force, any amount payable, it does not have an overriding provision for IPC. It is in the Central Excise and CGST Act, it says notwithstanding anything to the contrary, and has the additional words save as otherwise provided and covers the insolvency and bankruptcy code. So all the subsequent decisions of the courts which are held that dues to the GST department is not a secured debt, it is an operational debt, have distinguished Rainbow Papers based on the wordings in the respective tax laws. The intention of the government was definitely to alter the priority of the dues to the government and to put it on a lower priority. And there was a discussion paper issued by the Ministry of Company Affairs calling for public comments in 2023. And it also recognizes that the government dues are not to be given priority. It shall be treated, mere operation of statute will not make it a secured creditor. And it proposed to clarify that only when security interest is created pursuant to a transaction with a corporate debtor, the government can be treated as a secured creditor. I have raised a few questions. The intention of the government is, of course, very clear that the government dues should come lower in the order and it should not be coming first. But if you look at the Supreme Court judgment in Rainbow Papers, the subsequent decisions differentiated only based on save as. In the decision, they are referring to save as provided. in the GST law, it is save as otherwise provided. Is the meaning of the word save as otherwise provided different from notwithstanding anything to the contrary? This is a question that on which I want the views of the forum. Jatin sir?
We'll hear the others also.
Others, your views? Maybe if you have no answer, maybe you can say no answer.
Notwithstanding is more like an overriding effect, while save as otherwise provided is a little limited exception per se, is what I understand.
Is it like takes the way and give the way?
Sorry, my lord, what did you mean by that?
So notwithstanding means the current law will override to other act. Save as provided means this act will give way to the other act.
Agreed.
That means one and the same basically.
I think only if the other law is contrary, the provisions of other law is contrary, to that extent it is overriding. Otherwise it is in line with the provisions of IBC. Even if there is a provision which is contrary, then I think it is saving that contrary provision of IBC.
In this comparative table, who says so, Bhuvaneshwari, so the Central Excise Act and CGST Act, since there is this save as per se mentioned here, so IBC will override here, but for the purpose of VAT Act will have the overriding effect. Is that your proposition, Bhuvaneshwari?
No. I am just asking a question. The Supreme Court in Rainbow Papers, in the context of Gujarat VAT Act, said Gujarat VAT Act, it says notwithstanding anything to the contrary. There is nothing to say that IBC will override this provision. But of course, IBC says notwithstanding anything to the contrary in any other law. It said that under Gujarat VAT Act, by the operation of statute, there is a security interest which is created and the government dues is dues to their secured creditor. Whereas the subsequent decisions and also the circular which has been issued by the department treats the dues to the government as operational debt. So my question is, the distinction that was made was in Gujarat VAT Act, there is nothing like save as otherwise provided. Whereas in excise and CGST, it says it is save as otherwise provided. So we saw that IBC says if there is a security interest by operation of law, you are a secured creditor. GST Act also, only if there is contrary provisions in CGST, then you look at overriding section 82. So section 82 also says the government will have first charge.
Okay, I'll give some background. We'll take one example we'll take. Suppose there's a company that has taken bank loan for purchasing machinery. 10 crores bank loan, 12 crores machinery purchased. So the bank is very comfortable with the security of the machinery, and the company goes and takes 100 crores of unsecured loans. In case of insolvency of this company, is the bank safe, or the bank is fully exposed to the insolvency risk?
The bank is safe.
That is the purpose of a secured creditor. A secured creditor's security interest in the asset, as long as the asset is not destroyed, he is agnostic to the liquidation process, insolvency process, whether CIRP or liquidation. Now, a secured creditor need not bother what happens in the insolvency proceedings. My money is safe. What Rainbow Paper said is, GST VAT department is a secured creditor, which means as long as the total asset of the corporate debtor exceeds the total claim of the VAT department, there is no risk to the government. So Rainbow Papers basically kept VAT department above the IBC proceedings itself, neither section 14 nor section 53. If we keep that, this is the effect of a secured creditor versus all other creditors, then we have to examine whether Rainbow Papers is correct or not, and why courts are struggling to overcome Rainbow Papers. The way to overcome Rainbow Papers is either by showing that the section that Rainbow Paper was rendered based on is different from the section in GST Act, or to say that Rainbow Papers is outright wrong. Any questions about the legal effect of a secured creditor versus other creditors?
No, sir.
Can we then say as a corollary that a GST department is an unsecured creditor?
Yes.
If GST department is treated as they are an operational creditor, no problem with that. But are they an unsecured creditor? Which means those who have security interest will take higher priority. Now, I'll give you another example of the same variation of the same example I gave earlier. Suppose the term loan is 20 crores and the machinery is realizable, we can realize only 12 crores. So the secured creditor, to the extent of 12 crores is secure, to the extent of 8 crores is unsecure, or in 12:20 ratio, he will get a rateable security in all claims that he makes. These are the distinctions that we have to examine in the case of liabilities arising from the VAT Act versus the GST Act. Keep these two examples in mind, and now please examine section 48 versus section 82.
So another question.
Oh, totally different question, huh?
No, same. If it is a secured creditor, considering for some reasons the same analogy of VAT is extended to GST, can there also be plea made that the liability would be restricted to only last 2 years and not the all historical liability?
Why 2 years?
Because of the IBC code?
No, I will cover it in the subsequent slides, Venu.
Okay.
Okay, sir, is the meaning of save as otherwise provided, is it different from notwithstanding anything to the contrary?
No, ma'am. See, notwithstanding, see, we don't have to find some difference just because different words have been used. If you see 82, notwithstanding anything contrary contained in the law in any law for the time being in force means 82 will prevail over any other law that says something different except IBC. Except IBC, no other law can come in and override what is stated in 82. That's all.
So can we say this RERA judgments, safeguarding home buyers?
So that is a welfare legislation. You are
Right.
trying to, cross-pollinate across species.
Hmm.
That is
Sir,
a
do you
welfare
agree with the
legislation.
rainbow decision, sir?
Sorry?
Do you agree with the decision?
No, that's not allowed. I shouldn't give an above the Supreme Court view about what Supreme
No,
Court
we
says.
want to know your views.
No, we go ahead. We haven't finished the discussion. என்ன சொன்னாலும் வரப்போகுதுங்கிறீங்க. You please proceed with your presentation.
Okay.
You're only saying, can address the question of notwithstanding and save as what is to do. I will proceed.
Okay, so
One aspect I think we are missing here. The Gujarat VAT Act says notwithstanding anything contained in any other law. We also have IBC saying notwithstanding anything contained in any other law. So now the issue is the state VAT will say that I am superior because I am enacted prior, but IBC will say I am enacted later, I am superior. Save as otherwise is very clear. 82 of CGST Act is very clear. They are saying, okay, IBC will take precedence. Similarly, excise law. Whereas VAT Act, Gujarat VAT, or not only in tax laws, it happens in other laws also. Now, VAT Act says notwithstanding anything contained in any other law. Now, IBC also says notwithstanding anything contained in any other law. Then how to bridge this? How to bridge this? I think this is one aspect I think we have missed out. So, madam, your views on this?
I think, okay, in Rainbow Papers, basically, the Supreme Court said that by operation of statute, a security interest is created even under the provisions of IBC law. So it looked at IBC law. Okay, let us look at the provisions of IBC law. There is an operation of statute. It does not contain the words that the provisions of IBC will prevail over this. Since there is a security interest which is created by operation of law, the VAT dues under GVAT Act will be a secured debt. And hence, after the in the waterfall mechanism, after the CIRP cost, the secured creditors come and the VAT dues will fall there and not fifth under the section 53 waterfall mechanism. This was the decision. So the question is, most of the tax laws will have the provision that in respect of tax dues, the government will have first charge. By having a provision in the statute, is a security interest created. That is why I brought in the discussion paper of Ministry of Company Affairs, which proposed a clarification to be issued saying it has to be a consensual transaction or agreement and not by operation of statute.
Madam, I am just asking the fundamental. Two laws, exactly the same word. Both are under
IBC
Article
will
265
prevail
of the
over
Constitution.
other law.
Yeah, both are under Article 265. They pass the test. It's a very simple thing. Both the laws, says notwithstanding anything contained. Let's not get into secured, unsecured. generally, as I understand in CIRP, there are other Supreme Court decisions where it clearly says whether it is income tax dues or VAT dues or sales tax dues, they all have to come later in the line. There's nothing like they can't be treated on par with the secured creditors. They're all like operational creditors only. No,
Okay.
they've gone even to the extent of saying that the tax dues, even they have to make a claim once the moratorium kicks in, once the advertisement is done. Even they have to make a claim. Now, for example, income tax fellow, he cannot just sit quiet. Maybe there was proceedings before the CRP, but subsequently even he has to take a claim. Otherwise, he will lose out. He can't come back later saying that no, even my dues are there. That is not possible. To that extent, there is clarity. Now, my simple question is, both the laws are saying notwithstanding anything contained.
Sir,
Now,
that is what
both
she
of them
answered.
will say, I
Sir,
am superior, he is
Vijay,
superior. So
Vijay.
why I brought this to your attention was, see, somewhere I read there's another case law which says the enactment that happens at later point in time will take precedence.
Vijay,
Sir,
you are explaining yourself 2 times. She answered you before you started the second round of discourse. She said IBC will prevail. You didn't hear that.
yeah, I'm sorry. Then I didn't hear
You
that.
hear? She said it. She dropped the mic after she answered your question, but you're continuing to speak to yourself.
Well, I'm sorry, I didn't hear that.
Ah.
So that was the question. Because
So actually, Vijay, so what's happening now is all tax dues are treated as an operational debt, not as a secured debt. But because of the decision of the Supreme Court in Rainbow Papers, any dues under the Gujarat VAT Act is treated as a secured debt. I went through a couple of resolution plans. Okay, there is a case law that I'm discussing subsequently. So I wanted to follow what happened subsequently. There is a due to the Gujarat government under VAT Act as well as under GST. The VAT Act is given priority as a secured creditor, and the GST dues is coming as operational debt. So this differential treatment is being applied because of Supreme Court decision in Rainbow Papers.
Madam, but what in case of central excise? Because central excise does not save 53 or the IBC code. It just says other provision of the Companies Act. So is it pari materia with IBC? So excise also cannot make a claim.
Deepak, IBC is a successor statute to these statutes. Correct, no?
Right.
Then in 1944, they did not have the 2016 code to include it, isn't it? Or the year when they introduced 11E. General Clauses Act tells us that when the substance of an act referred to in an earlier enactment is subsumed or substituted in a subsequent legislation, you have to read it harmoniously. Central Excise Act should have been amended along with amendment to GST, IBC, but not making a corresponding harmonious amendment is not fatal to the remedy that will avail.
Fine, but what is the difference in the Gujarat VAT versus excise? Where in Gujarat VAT they've said that that will get a priority.
And that's the whole point what Madam is explaining about Rainbow Papers.
So actually NCLAT in the context of central excise, I mean, it uses 11E. It says that since the word save as otherwise is provided, the provisions of IBC will prevail. So that is the point that I actually wanted to discuss as to whether the decision of the Supreme Court in Rainbow Papers how the other decisions under other tax laws are being differentiated because of save as provided and save as otherwise provided. Now I will move on to the next point. So what is the order of priority? We already discussed saying that it will be an unsecured operational data. In the waterfall mechanism, the first is the insolvency resolution process cost. There is no doubt on the tax dues prior to the CIRP period. It will come either under the fifth bucket to the extent of tax dues for the period relating to 2 years. It uses the term preceding the liquidation commencement date. So the question that I was considering was, in a CIRP process, will the entire dues of the government, irrespective of the period to which it pertains, will it fall under clause E, or only to the extent of 2 years preceding the CIRP commencement date will fall under E, and the dues pertaining to period prior to 2 years will fall under the next bucket F under any other debts. The wording used under section 53 is preceding the liquidation commencement date. So can I make it applicable even for a CIRP process to make it apply to 2 years preceding the CIRP commencement date? So when I look at, I think section 30 subsection 2, which provides conditions. I don't know in which screen I have that section. I'm sorry for that. When you evaluate a resolution plan, one of the conditions that the resolution plan has to meet is it has to provide for the payment of operational debts in a manner which is not detrimental to what they would have received on in the case of a liquidation. So when you evaluate the priority of debts on the CIRP commencement date when a resolution plan is submitted, it has to the extent of tax dues of the 2 years, the government should not receive anything less than what they would have received in the event of a liquidation. And for the tax dues prior to the period of 2 years, it definitely, I feel it falls under clause F. This is how I concluded. I raised this query with a couple of practicing insolvency professionals also, because when you go to the IBBI website and look at the corporate processes and the claims that are submitted, there the claims that are submitted, it doesn't necessarily list it in the waterfall mechanism. There is only one tab for all government dues, irrespective of in which bucket it will fall. Like I was talking about the case involving dues under Gujarat VAT as well as dues under GST law. All the government dues were in one tab. I mean, it is the portal. I can't say the portal will define the order of priority. So in my view, even in a CIRP process, it is only the tax dues for a period of 2 years prior to the CIRP period, which will be under clause E, and the rest of the tax dues will fall under class F. This discussion probably is a theoretical. I did not see any case laws, whether it will be E or F, probably because there was no need to raise that question, as resolution plans normally provide for a far less amount than what is due to the operational creditors. It only has to ensure that they don't get anything less in the CIRP process than what they would have got in liquidation process. So as long as the amount is more than that, probably there was no question regarding whether it was coming under E or F. And this is for the tax dues prior to CIRP period. What about the tax dues during the CIRP period? If there are some tax which remains due even for the CIRP period, will that be also an operational, unsecured operational debt under class E? So it is actually pertaining to the CARP period and not prior to the CARP period. And the definition of insolvency resolution process cost under IBC includes any cost incurred by resolution professional in running the business or corporate debtor as a going concern. So I came to the conclusion that the GST dues for carrying on business during the CIRP period is a cost that he is incurring in running the business. And so, as far as tax dues of the CIRP period is concerned, it will come under the first bucket, insolvency resolution process costs. Any other views?
I agree with the view.
Others?
I have a small question. So operational debt means it's like day to day, whatever is happening in the day to day business, right?
Like financial creditor is defined as a person who has lent money.
Mm.
So the person's all other debts will come under operational debt, including dues to the government.
So operational debt can further be classified as secured and unsecured.
Yeah.
Got it. Okay. Thank you.
Jatin sir.
Go ahead, madam. Go ahead, madam.
So coming to the next point, can appeal be initiated and continued during CIRP? Section 14 prohibits institutional suits or continuation proceedings against the corporate debtor. It does not prohibit continuation of legal proceedings or any other action by the corporate debtor. So appeals can be initiated and continued by the corporate debtor during the CIRP period. So I also came across a couple of case laws which supported this view that the corporate debtor can continue the appeal proceedings.
Madam,
And
1 minute, 1 minute, 1 minute. The board of directors of the corporate debtor will get dismissed once the IRP is approved. Correct, no?
yes, sir.
Now the corporate debtor will file appeal under which GST login? You should not simply brush this sentence. Yes, the judgment is there. You tell me exactly. Corporate debtor GST number is X. Insolvency professional gets another GST number Y. Both having same PAN number. How appeal will be filed by corporate debtor? Whose OTP, PTP, TTP will be used to file this appeal?
Okay. This is a practical problem.
Legal problem. Why practical only?
Because you are not able to log into using the GST credentials of the corporate debtor to file an appeal.
It is not only login problem.
Okay, authority.
No, it is locus standi to file an appeal in the name and title of the dismissed corporate debtor, where the board stands dismissed. Can the insolvency professional appear in the hearing even if the appeal was filed earlier? Can you as a chartered accountant get power of attorney signed by the insolvency professional to represent the corporate debtor's appeal filed before IRP was appointed? Everything comes to a standstill. Otherwise, we will end up making a mockery of Section 14. Institution of suits or continuation of pending suits or proceedings against the corporate debtor will have to continue with prejudice. Who will appear? Now the forum where the suit is taking place will have to decide. Now, let's say you appear before commissioner and explain to him saying that I am the power of attorney holder of the IRP or the IP. I don't have access to any facts relating to corporate debtor for the disputed period. Now, will the commissioner proceed to conclude adjudication without the information because time limit is running out, or is the commissioner also protected by section 14? Section 14 permitting continuation of proceedings, is it going to cause prejudice to the department? Section says you can continue. What were you doing? Why didn't you conduct hearing? Why didn't you pass order? See what happened, time limit crossed. Or can they say, I could not have proceeded with the adjudication. Therefore, section 7410 has to be read subject to 14.
So there is a provision in IBC, section 60, subsection 6, which says that the moratorium period, notwithstanding anything contained in Limitation Act or any other law, the moratorium period shall be excluded in computing the limitation.
But moratorium says you can continue the proceedings.
That is okay. That is a
So
corporate
therefore-
debtor. It says that the corporate debtor, he can continue the proceedings.
No, against the corporate debtor.
No, this section 14 is prohibition. It says section 14 prohibits proceedings against the corporate debtor.
So therefore, commissioner is safe.
Yes.
Therefore, in the hearing, we have to go and tell him to keep the matter in call book.
Yes. That is for the appeal proceedings initiated by the department. If it had been
Go ahead, go ahead.
okay, if it had been an appeal by the corporate debtor, you can initiate the appeal as well as continue with the pending appeals because it is proceedings by the corporate debtor. So since
But
section
corporate
14,
debtor himself
Mm.
is not in a position to do anything. Can order issued in X GST number appeal be filed from Y login?
Yes.
Okay.
How,
Okay.
madam? It has
So
to be next
practical
login only.
issues, you can always, okay, this is all I can say. These are all issues which are yet to be resolved. And in case of all these practical issues, you have to make an application to NCLT and NCLT will give directions. Based on the directions, you have to approach the department and request them to accept the appeal.
No. NCLT cannot give directions to GST department.
Sir, NCLT cannot give directions to GST department regarding implementation of GST law. But this practical procedural issues, if portal, you are allowed to make an appeal, but the portal is not allowing you to make the appeal, then NCLT can give directions to that extent.
No, see. Can NCLT give directions to Joint Commissioner GST? Tell me.
Sir, I think so, because even that is another case law where I think NCL, NCLAT, Mumbai, that it was a case where the department had blocked the electronic credit ledger during the CARP period, saying fictitious purchases, and an application was made to NCLT, and NCLT. Not High Court. Mumbai High Court basically gave a direction to approach NCLT for directions. I have that case law reference in this slide. I don't have it, but
We'll come to case law later.
Okay.
You question, you give answer. Case law ಎಲ್ಲ ಬರುತ್ತೆ ಹೋಗುತ್ತೆ.
Okay, even in the context of prior to IBC, the question was whether the company law tribunal can adjudicate on everything. And there was a clear decision saying that in the context of Income Tax Act, it is not company law tribunal which can hear all those proceedings. And all those proceedings had to happen in the income tax forum. Here, it is not the question of interpretation or ascertaining the liability under GST law. It is just allowing the resolution professional to make an appeal. So that I feel the NCLAT has the powers to direct the authority to accept. They are not giving a decision. They are only directing them to accept that application.
Madam, giving direction is called issuing a writ. Unless somebody is coming within the administrative hierarchy of some appellate or adjudicating forum, directions cannot be given to somebody beyond my jurisdiction. You understand? NCLT is an adjudicating authority, not even an appellate authority.
Okay.
So to issue writ, if writ can be issued by NCLT, then deeper discussion may be required to appreciate that.
Okay. Yeah, we will park this question. Okay. Again.
Madam, one point. Sorry. Sir, legally, why the insolvency professional cannot continue the proceedings which were erstwhile continuing by the old company, old directors? I'm not looking practical problem. I'm just looking legally, assuming there was a claim and company said, I don't agree with this demand. And the appeal now needs to be filed against an order. Why shouldn't the RP continue the old GST number and file an appeal?
So the RP is not somebody who's interested in running the entire business. He is there for a short period.
But in that period, whatever needs to be done, he is also supposed to be done, no, sir?
So therefore, government feels he should not be given the old login. That is why they have amended the rule. They have issued a circular specifying the steps that he needs to follow. When there is a
new actions.
So that circular also, they subsequently modified. They said that if the corporate debtor has been filing the returns and doing all compliances till CIRP, then you don't have to apply for a separate registration. You can continue in that.
Now you decide whether a new number will be taken or
new number is required only when the CD was not filing the returns prior to CIRP commencement date. And
Madam, we'll identify the stages. In January, IRP is appointed. In July, the CIRP proceeding is approved and it is initiated. There are various in these 6-7 months. There are many things that have taken place causing the delay. Now, for the 6 months, what should the IRP do to preserve the asset? Should he take ITC? Will he cross 16(4) time limit? All these questions are there. At the granular level, what should the IRP do? Tomorrow, the IRP can be kicked out and a new RP can be appointed.
Sir, in the example that you gave, what is the event in January and what is in July, sir?
January is where IRP is appointed. Interim resolution professional is appointed.
Okay.
CO advertisement has to be made. COC has to be convened. 6 months is lost because the equity holders are challenging the entire proceedings. NCLT is examining the validity of the claim under 9 or 11. there is some matter that is carried to NCLAT and it comes back by June. July, IRP is kicked out, IP is appointed by NCLT. Now the actual process commences. COC meeting is called for after doing valuation of all the assets. Now in the 6 months, who should file monthly returns? Can department say, you didn't file returns, I'll cancel your number. Then I will pass best judgment order under 63.
Once the CIRP application is admitted and IRP is also appointed, a CIRP process commences.
No, but in
And,
between, I'm telling in my example, there are certain challenges to the appointment itself.
It's only challenge and the initiation itself is not stayed.
No, madam. When there is a time lag between IRP's appointment and COC meeting. In this interim period, who should file the returns? You are saying the circular says if CD has been filing returns.
No, even
As
in
soon as-
IBC code, till the appointment of IP, it is IRP who is responsible.
Correct. Which means CD has not been filing returns from January. So who will file those returns? Because there are other implications of cancellation of registration, best judgment order, etc. can come about. Tomorrow IRP should not be pulled up saying dereliction of duty. That is why circular is there saying, I mean, this all goes back to Venu's question, why can a dead man's ATM card not be used? The dead man's ATM card cannot be used because he is dead.
No, here the CD is not dead. They are trying to
Oh.
keep him
No,
alive.
madam.
He is in ICU.
No, I'm only, forgive me the analogy. Once IRP steps in, IRP will run everything. He cannot use his PAN number to get the number registration. He has to use the CD's PAN number. Venu's question is, why can IRP simply not use the old GST number itself? And Tuesday morning is to discuss granular things.
And I believe that you can make an application to NCLT for directions.
No, some basis you have to give. You cannot declare the law.
Because under IBC, the adjudicating authority is NCLT.
He will adjudicate matters relating to CIRP proceedings. They will not enter the role of a high court.
Correct. So, okay, here under section 14, the prohibition is not for the corporate debtor. So he has to file an appeal, but because of practical difficulties, he is not able to file an appeal. He can always make an application and ask for directions.
No, I appreciate the logic in what you're saying, but I'm asking for the law.
Okay.
It seems very logical, but it's not all logic that works, no? If I'm the department and you have filed an application to NCLT to give me directions, I will file objection to your application itself saying NCLT has no jurisdiction to give direction to GST or GSTN. How will they overcome that? Because the
IBC has a notwithstanding anything to the contrary contained in any other law. Can we not say that the overriding provision of
constitution also. No, I don't need. I'm only saying, please give it some consideration and provide some answer as to how NCLT will have jurisdiction to give directions to GST department without showing a basis in the law. They have to show that, look, this is the section under which we are exercising jurisdiction to give you direction.
Okay, I'll come back on that, sir.
All. Venu, What is your view, Venu? How can IRP
Sir,
or
I'm
IT
still,
use login of the old login?
sir, I'm still thinking, but I still feel that they should do whatever they were supposed to do in their period. I don't have an exact answer to counter you, but I am still of the view that he has to use the old login and continue to complete what he is supposed to do in that period.
Now I'll give an
But I get your
example.
point.
Suppose I am Commissioner Appeal. I am
Yeah,
Additional Commissioner Appeals.
right.
I noticed that the directors are not appearing. The authorization given to Venugopal has been signed by some IP.
Correct.
Then I'm finding that on the portal, the GST number is the same.
Right.
I will say that this is abuse of law. IRP has no jurisdiction to use this login, and I will dismiss the appeal as non-est.
No, but can I not saying that the transactions happening during my period is happening through my login? But this is an appeal of the erstwhile, but it is being taken up now. Since the order, everything is there in the old login, and I am the one, like I am a suo motor director now. So it is as good a old director went off and new director came in. So I am the authorized person of the company and I am continuing the proceedings.
Again, you are giving logic. This is not, I will dismiss the appeal because see the decision to file appeal in the wrong login is with prejudice. See this entire thing, I'm just telling you, this entire thing involving CIRP proceedings requires multiple writs to be filed in High Court to get necessary directions.
Got it.
If we on our own take law into our hands and start doing what we think is the law
Right.
should be, then in the name of interpretation, we are not interpreting, we are legislating.
I get what you're saying.
But Jatin sir, once CRP is instituted, don't you think the appeal suits, everything will abate?
Everything that we are not coming to the abatement point here at all. We are all finding how to file return, how to keep monthly retainer going. We are not discussing abatement of proceedings. See, a GST proceeding is nothing but a civil suit. So we have to refer to some provisions of civil procedure code here.
Madam should answer now. Madam, once CRP is instituted, I think somewhere it is there in the IBC, that all appeals, suits, petitions, etc. filed will all abate.
No. There is no provision in IBC saying that once CIRP is initiated, it will abate. There is only moratorium under section 14 in case of CIRP process and 33(5) in case of liquidation. There is only moratorium. And section 60 subsection 6 specifically provides that notwithstanding anything contained in Limitation Act or any other law, the period of the moratorium will be excluded in computing the limitation period. So it is not that all the suits, everything will abate. But once a CIRP resolution plan is approved, then you cannot make a claim for the period prior to the date of the approval of the plan. So it really serves no meaning if any suit is initiated, that is being dismissed by the courts because no claim can be made for a CIRP period after the approval of the resolution plan, because the resolution plan invariably contains a provision that the claims which have not been considered are all extinguished. So there is a provision for extinguishing the claims which are not part of the plan, not for extinguishing any suit or proceeding. And
Madam,
Jatin
once
sir,
RP is there, how can everything will come to an end? In India, the litigations continue. And if you say once CRP is initiated, if the appeals or suits are not abated, then you mean to say it should continue even after RP, correct? Logically.
no, there is a moratorium. which prohibits initiation or continuation of suits of proceedings against the corporate debtor. So once CARP process commences, you can't continue with any suit or proceeding against the corporate debtor. So I said that the corporate debtor can continue, and Jatin sir raised the point as to how the resolution professional will file a suit or appear for the corporate debtor. So, and I said that you can make an application to NCLT, and he said, how can NCLT be the authority to decide on these matters? So, Jatin sir, under section 60 subsection 5 of IBC code, which contains provision regarding adjudicating authority, it says, notwithstanding anything to the contrary contained in any other law for the time being in force, the National Company Law Tribunal shall have jurisdiction to entertain or dispose of. I'll come to clause C. Any question of priority or any question of law or facts arising out of or in relation to insolvency resolution or liquidation proceedings of the corporate debtor or corporate person. So because of this provision, I said you can make an application for direction.
Now we'll need to see some authorities to understand, does it refer to matters connected to the application, COC meeting and its disposal, or all matters pertaining to corporate debtor? Tomorrow there can be a trademark infringement by corporate debtor.
Okay,
or
such
by
proceedings
somebody
can be
else.
before. Okay. In the context of prior to IBC code, there was a judgment which said that the income tax proceedings and all that cannot be before the adjudicating authority, before the NCLT. Because NCLT is not authority which can look at the provisions of Income Tax Act and give an adjudication. But this, I feel, is a matter which concerns the right of the corporate debtor resolution professional to continue the proceedings in the name of the corporate debtor. And I feel that section 60 subsection 5 contains a provision in IBC code to continue with such proceedings.
All right, okay.
Okay, so
Madam, yes, this corporate debtor, when this moratorium period comes, only suit against the corporate debtor is not maintainable one. Once this moratorium period starts, the management will get dissolved, but the corporate debtor will continue because the management, it is like a change in the board of directors. Now the management will go off, all the directors, IRP will comes in. So is that not that I can apply to GST department and get the authorized signatory changed? In the
Manila, you have
existing
seen
one.
the circular?
Sir, I
You
seen
see?
that. I
and
seen.
that circular
So
basically
it's not
says
like change of directors. You don't sign everything as the new managing director. It's little different, no? Don't you feel?
No, because they said, sir, in the circular also. See the in 148, what they want to resolve is in the case where returns are not filed and there was a practical difficulty to file the returns and pay the regular taxes, how we discussed in the sale by the RP of the assets or other things, the new liability that is arising out of this proceedings, the taxes should have been paid and the return should have been filed. There was a practical difficulty because when the moratorium started, there was a pending returns and other things which they could not do it. To resolve that, they come in and they said that you can apply for a new registration and take it. If there is returns are filed till date and there is no issue, then you can modify the authorized signatory and continue the same login was clarification they given.
Okay.
so the notification which introduced a special procedure was subsequently modified to say this special procedure needs to be followed only by the resolution professionals or the corporate debtors who are not been filing the returns. I mean, I agree with what Maila said.
Oh.
So again, this case law is in the context of continuation of proceedings by the corporate debtor. In this case, the defense that was taken was that the moratorium proceeding under section 14 did not prohibit the corporate debtor from pursuing the legal proceedings or suits, and hence section 60 subsection 6, which provides for extension of limitation period in cases covered by moratorium, will not apply to suits by the corporate debtor. The Supreme Court took into account the fact that the moratorium under 14 does not prohibit action for the corporate debtor, but it said that during a CIRP process, the resolution professional, he will not have all the information, and he might not, it might not have come to his attention. He could have always overlooked filing a suit or a proceeding. So the extension of the moratorium period for computing the limitation will apply even for proceedings by the corporate debtor. In para 24, what I have displayed on the screen, it said that it may be true that proceedings by corporate debtor is contemplated. It is not impossible to contemplate that the resolution professional, for whatever reason it may be, does not discharge his duties and conduct proceedings in all matters as he should. We have noting this as the lawgiver excluding the period of limitation. So they said 66 will apply, benefit will apply even for proceedings by the corporate debtor, even though the moratorium under 14 did not apply to him.
So you are saying that GST officer will not take recovery action even if appeal is not filed?
Yes, sir. He has
See,
to lodge the claim.
he has to?
He has to file his claim with the IRP. Tax has been determined. He is not able to initiate recovery proceedings because the moratorium period has started. He has to only file his claim. He cannot initiate recovery, and he cannot.
Nothing to be done now. There is balance in the electronic credit ledger, balance in the electronic cash ledger of the corporate debtor. Appeal also is not filed. 4 months is over. He has provision powers in the law to appropriate and adjust the dues. You're saying he should not do that?
Yeah, because IBC prohibits that, and the provisions of IBC overrides the provisions of GST law.
But in this section 60 subsection 6,
Mm.
they are trying to legislate here by saying that this limitation will apply on both sides. This is not there in the law. The court is trying to create a law here.
60 subsection 6 is for extending the limitation period in view of the moratorium. And we are giving the benefit of the extension even for the corporate debtor. Even though under section 60 subsection 6, if you read it strictly, it is not there.
One point to consider, when there is something that is needed in the law, but it is not there in the law, what would we like to do as students of this law? Do we say that there is no answer in the law? Or as teachers of this law, we try to fill up the missing blanks and give our own answers? How do we view the problem statement? Do we have an obligation to give answers to all questions, whether we know it or not? Or do we have to stop saying that there is no answer to this situation in the law, therefore you have to file a writ for directions? Tomorrow, to enforce any position we are taking, we need an authority. It can come from the law or from the court. Should the advice be that please file a writ petition, seek directions against the parties in question to follow certain things? Whatever view you want to take, press for that view to be approved by the court as directions, or do we ourselves formulate an answer which looks logical and issue it to the client as our opinion?
we should make an application and get that directions.
So our conclusion should be, what are the use cases for which we can find an answer in the law? What are the use cases for which there is no answer in the law? Therefore, in those cases, what should be the pleading before a court to get directions, and against whom those directions should be got? Shouldn't that be purpose of Tuesday morning debate? All the situations that are contemplated in the circular are contemplated. Situations that are not contemplated in the circular, if we logically extend something, bear in mind that protecting the interest of revenue is on the minds of the officer also. He also wants to know how he can square his liability, square the recovery of the liability. So therefore, he will also try and see which are the areas where the IP, IRP are fumbling, and he will try and take advantage of it, not filing appeal, things like this. This is the chart, is it?
The table where I summarized whether appeal and adjudication proceedings can be initiated, continued. Okay, so coming back to the point that you raised regarding the balance in the electronic cash ledger or the credit ledger, whether it can be appropriated for the dues prior to the CIRP period. So what my understanding of what you have said is the department should make an application, or will that happen, or the department will by itself appropriate, and then it will be left to the resolution professional to make an application before the adjudicating authority. Practically, that is what happens.
Correct. Any money lying with the department, can we say is part of the liquidation estate?
Yes.
If money
That
is
is
already
a-
with the department, no, there are many cases where money is already given, bank guarantees are given, etc. You can't include that as a 100 crore liability, 100 crore payment made under protest. Is it zero liability pending, or is it 100 crore asset liable to be recovered from GST department? See, these are the use cases. Madam, don't be anxious that you have to give answers to all questions. Our role is to list questions for which there is no answer in the law.
Okay. So if the department by itself appropriates the balance in the cash ledger as well as credit ledger towards the tax dues, then such adjustment is not necessarily in line with the waterfall mechanism.
So therefore, you have to now file a writ to get directions that the department withdraw such appropriation that they have made. And a finding has to be reached on that. It is like a machinery given to a job worker. Because of CIRP procedure, the job worker decides to keep that machine on his own for himself and starts using it for his business. You have to realize all the assets. That's the role of the IRP, no?
Okay. So when the department adjusts it, the IRP has to make an application before NCLT objecting to such appropriation. And in the context of income tax law, there is a decision by NCLAT New Delhi. There, in a liquidation proceeding, the department adjusted the refund against the income tax dues, and an application was filed to NCLT. And the NCLT said that, okay, the refund adjustment is within the amount that the department would have received under section 53, it can keep that amount, and to the extent that exceeds the appropriation and the amount that it would have received, it has to return the money, and it should form part of the liquidation estate.
Got it.
Okay, so when there is a difference in the moratorium provision under section 14 in CIRP process vis-a-vis the moratorium under liquidation. The liquidation proceeding moratorium, it contains provision only for prohibiting initiation of any suit or legal proceeding. The word continuation is not there, and also it is referring to legal proceeding and not proceeding. So a matter of whether adjudication can be initiated or continued during the moratorium period and during the liquidation period has come up for decision in many case laws. We have the Supreme Court in the context of liquidation in Sundaresh Bhatt liquidator of ABG made a passing observation. It was not the question on which the decision was to be given. It said that there is no bar in adjudication being carried out during the moratorium under section 14 or section 33. This case law was regarding liquidation, and matter was also not whether adjudication can be carried out. The question before the Supreme Court was whether Customs Department can appropriate the goods against a demand that it raises during the moratorium period. This has been distinguished in subsequent case laws where they have said that the facts of ABG shipyard will have to be differentiated with the facts of other disputes which are before the authorities, and broadly they have held that adjudication can continue during liquidation, but whether adjudication can continue during CIRP period, we have a decision of High Court of Karnataka which has stayed even audit proceedings under section 65. This was a single member decision, and the department has filed an is on appeal against this, but I don't see any developments in the High Court website, nor did I get any decision on the department's appeal against this decision. And Delhi NCLAT also has held that during section 14 moratorium, assessment proceedings cannot be carried on. So the judicial precedents are holding that adjudication proceeding cannot be carried during CIRP moratorium period. So what about moratorium period during liquidation? Because liquidation proceeding is prohibiting only initiation of a suit or legal proceeding. There is nothing regarding continuation. So there is this ambiguity which is there as to whether this proceedings which were prohibited during the CIRP moratorium period, can it be adjudication proceedings, can it be continued when liquidation commences? So this point also was covered in the discussion paper of MCA. It says it recommends that 33(5) be amended to prohibit even continuation of suit or other legal proceeding. So as the judicial precedents stand today, no adjudication during CIRP and no initiation of adjudication. I have a question mark on that. No. Section 33 prohibits initiation of suit or legal proceeding. Is adjudication a suit or a legal proceeding? But Supreme Court in ABG shipyard said that you can continue adjudication proceedings even during moratorium under section 14 and 33. So there is an element of confusion, and I just brought this table to fill up the blanks, which I feel I should not have done. My question is, what is the difference between us proceeding and a legal proceeding? Is adjudication a proceeding or a legal proceeding?
Adjudication is specified to be a quasi-judicial proceeding. So it may be treated as a legal proceeding. If it's not a legal proceeding, then it must be an audit, investigation, pre-show cause notice stages.
Okay. Okay. So, can adjudication proceedings be continued after CIRP? There are clear case laws which said that if you are not made the claim before the RP, when CIRP has commenced, after the approval of the resolution plan, you can't come and make a claim. And all the claims which are not part of the resolution plan shall stand extinguished. And there was also a case law where the department initiated the proceedings for the period prior to CIRP after the approval of resolution plan, and it argued that it is not a CIRP due because it has been initiated after the approval of resolution plan. But the division bench of the Bombay High Court ruled against that, and it said that it is a pre-CIRP proceeding and it cannot be initiated or continued. I will skip the slides on provisions for individuals and partnership firms. And I just wanted to highlight the provisions of section 60 subsection 6, which extended the limitation when moratorium is in place. The subsequent slides are on whether department can cancel the registration for pre-CIRP dues. So moratorium prohibits any suit or proceeding, and so department cannot do that for CIRP tax dues. But what about the tax dues of the CIRP period? IBC provision, the explanation for section 14, it does not prohibit suspension or termination of a registration if there is a default in payment of the dues of the CIRP period. However, the department in the circular said, don't cancel, just suspend the registration. Okay. So the next question is regarding ITC eligibility. In the resolution plan, there are a major portion of the operational debt is extinguished. And so the CD has not actually paid those dues. The dues they are only extinguished. So how does it impact the eligibility of ITC for one is for the customers, another is for the corporate debtor. The corporate debtor, he has not paid. So will Rule 37 apply? If by the operation of Rule 37, the corporate debtor has to reverse the input tax credit prior to the commencement of the CIRP period, or even during the CIRP period, those dues become part of the resolution plan. A fresh demand cannot be made. But if the 180-day period is crossed in respect of ITC which has been availed by the corporate debtor prior to the approval of the resolution plan, and now when the successful resolution applicant is running the business, if the 180-day period being crossed happens during that time, will ITC be denied to him because the dues have been extinguished? The operational debts? I wonder.
Madam, can you say again?
Like the CD owes money to the operational creditor. Under the resolution plan, if he has owed 100 crores, probably the operation plan provides for payment of 10 crores to the operational
Right.
creditors. So 90 crores of money that he has owed to the operational creditor has not been paid.
Right.
Rule 37 talks about reversal of input tax credit in the event of the payment not being made to the supplier within 180 days. So if that 180 day from the date of the invoice is when the new successful resolution applicant is running the business, should he reverse the credit because the payment has not been made to the supplier? Those claims have become part of the resolution plan.
But look at the practically, all the costs which the resolution professional is incurring, they are the first level priority. What is not paid is the earlier directors' liabilities. So the reversal is happening in the old GSTN, which at all will again form part of the liability of the department, where department has to make a claim. Till that department has made a claim, it is not a reversal or liability. It is not an obligation of the resolution professional. Can we not take it that way?
So 180 days. So 180 days means he would have received, the corporate debtor would have received the goods or services during the CIRP process. So,
During the process, the
no, I
180
will just conclude because this thought came to me when you were discussing.
Yeah.
So whatever goods and services that he has received during the CIRP process, the cost incurred for running the business falls under the first bucket.
First bucket, correct.
CIRP cost. So definitely that cost would have been paid. So the question of having to reverse because those debts would not have got extinguished, and so this question may not arise.
No, this question is valid. All that I am saying is the reversal would come not suo moto, only from the claim that department has to make, is my point.
But Venu, isn't Rule 37 self-assessment responsibility? How can department be made to claim 180 days payment condition? Your credit itself is contingent upon you satisfying a condition subsequent.
Right. But that person who has to satisfy is no longer there.
No, person is still there. The person in charge
okay,
is
person
changed.
the person in charge.
So therefore, can you say that the credit that was considered as the closing balance sheet before CIRP process?
Most likely, these credits would have also got utilized and exhausted. Also, no, sir.
Again, don't change the question. Assume that credit
No,
is
okay.
sitting there.
We will say of 100, 60 used, 40 is still there.
No, the entire 100 is doubtful. When the IRP steps in, he has to do revaluation of all assets and liabilities. At that time, he must also examine Rule 37 non-compliance, how that closing balance of ITC he can treat as realizable. He should not treat it as a realizable value at all.
Right.
We are not trying to wash our hands off any responsibility here. In litigation, you can take very different act and take that.
But the fact is, most times the credit gets utilized, or only a very small amount would be left.
No, that is all. Even if it is utilized, it is wrong.
Correct.
On revaluation, he must now create a new liability for unpaid output tax because of non-payment to creditors.
Yeah, my point is, should he create a liability or ask
What is
the
your answer?
department to make a claim?
What is your answer? 180 Rule 37 is enforceable by department or voluntary to be done by assessor?
It was supposed to be voluntary, but if it is not done voluntary, department always during their audit inspection, they also check this point. So RP can always say that I don't know what happened in the past, and it is not my duty to look at what is supposed to be done by them, have they done or not.
No. Again, I don't know if that's academically you're arguing or you serious about this. IRP cannot wash his hands off when he
Opening
has done
unrecorded liability. See, this is an unrecorded liability, sir.
No, of course it is recorded. He has taken ITC and creditors are staring in his face. How can IRP wash his hands off and say, I don't know this, I don't know that? Then he's not a competent IRP. He should, he has passed an exam and become IRP. He didn't get
Right.
only authorization as IRP.
Right. Okay, so Rule 37, he has to do a voluntary thing. But in all the cases that I have seen, that area, all the insolvency resolution professionals have put it aside.
100% non-compliance does not make non-compliance valid.
I get your point. So I was like when this came up, I was of the view that okay, given that it was a past thing, and in the cases, all the cases I have seen, no IRP has picked this, sir. That is where I am. Okay, I get your point.
I'll give you another question. Can IRP find that there is unpaid TDS, ESI, PF? Can he decide not to remit it? When he takes over the books, can he decide not to remit it?
No.
There is the answer.
But what about like TDS was supposed to be deducted, not deducted?
That's an extension of your answer only. He has to do all the things that is lawfully supposed to be done. He cannot take advantage of the impending CIRP or liquidation possible. See, this is where integrity of the IRP comes up. At the end of the day, if an IRP has been found favoring somebody, one of the parties, his credibility is lost. He is on nobody's side. He's an independent. If independent professional is not independent, then he's not even professional.
Right. I got your points.
IBBI can take disciplinary action against those resolution professionals. They can suspend their authorization. They can levy huge penalty, fine.
Right.
The next thing is, what about the customers of the corporate debtor? The corporate debtor has supplied goods and services during pre-CIRP period, and he has not paid the tax to the government. 16(2)(c) condition is not fulfilled. So, is there a GST ITC reversal under Rule 37A? If the return would not have been filed if he has not discharged the tax dues. So Rule 37A automatically comes into effect, and the customers have to reverse the credit. And in the resolution plan, if 10 crores is due to the government, the resolution plan may provide for 10 lakhs. So will he get anything? Will the customers get back that ITC? Very unlikely. So when at the beginning of the CIRP period, when they have to submit their claim, can they as part of the claim include the GST which has not been discharged by the corporate debtor on account of which they have to reverse the input tax credit. Yeah.
The supplier has already given an invoice, which itself is a claim. How many times he should claim?
No,
the
sir,
customer-
corporate debtor has supplied.
The customer has got an invoice from the corporate debtor.
No, sir, this is the reverse. Sorry, the slide is, the heading is misleading.
Okay.
Incorrect. My question now is the corporate debtor has supplied goods and services. The customers of corporate debtor have taken input tax credit based on the invoices of the corporate debtor. Now the corporate debtor in the pre-CIRP period, he has not filed the return and he has not paid the GST. So 16(2)(c) condition is not fulfilled. So should the customers who receive the goods and services from the corporate debtor during CIRP period, pre-CIRP period, now they will be denied the input tax credit.
Okay.
So
They have paid
question was, okay, will they be denied? Is extinguishing the government dues, will that amount to not a failure, the corporate debtor not failing to pay the tax? I just raised that question and I said that no, you can't say that 16(2)(c) has been fulfilled. So the customers of the corporate debtor will be denied input tax credit of GST charged by the corporate debtor during pre-CIRP period.
We'll take two situations. The customer has paid the full invoice value to the CD. The customer has not paid the full invoice value to the CD. What is the responsibility of IRP?
So whether the customer has paid or not paid, okay, you are saying in terms of collating and tabulating the claims, whether he has to include.
See, if the CD has received money from the customer and misappropriated the GST amount by failing to remit it, it is one use case. Another use case is where the customer has failed to pay the invoice and now still hoping to extract the ITC out of that is another use case. Do you agree?
Yes, sir.
So what is their treatment? What IRP should do, what customer should do. Customer who never paid the entire money is better off keeping his mouth shut.
Yes.
But if he feels that his dues are legitimately payable, he should not be taking advantage of the CIRP process by failing to pay. He should pay what is lawfully due and save the credit. He should ensure that whether RP is going to discharge the GST collected on the charged on the invoice or he is going to misappropriate it. Because the customer is a nobody as far as the CIRP process is concerned. Here is the money I am going to give you. Please pay it to GST. He says, no, I will collect your money and pay it to secured creditors. I am not going to pay GST. Then the customer will say, I will pay you the basic amount. I will not pay you the GST.
Okay. So in the situation where the customer has already paid the CD, the entire amount including the tax, and the CD has not discharged that tax liability, the customer will have to reverse the input tax credit because tax has not been paid to the government.
As well as file a criminal complaint against the CD for financial fraudulent misappropriation of GST amount.
Okay, understood. Okay. Okay, with this.
Sir, I have a point. Sorry, madam.
Yes.
No,
Sir,
continue.
if the payments that is being made by the debtors, would include the taxable amount and the tax portion.
Right.
Now, in the waterfall mechanism, the GST due stands at 1 point. The current collections with the RP is doing includes of the old sales that have been made.
Right.
Assuming that the full value is outstanding, 100 plus 18, I'm collecting full 118 now.
Right.
So, is it an obligation of parking this money separately to the GST, or should include 118 in the waterfall? Anyhow, the 18 is lying as a liability to be paid, and
See,
which eventually
really-
may not get paid. If I put it in the waterfall mechanism, that 18 will not go to the government.
The realization of 118 from the customer is comes with a condition to remit the GST. By operation of IBC, 16(2)(c) cannot get defeated because there is no deemed fulfillment of 16(2)(c). Therefore, the corporate debtor will have to conditionally make the payment or move an application to NCLT to answer this question. If I pay this money and that fellow does not use it to remit GST and GST gets written off under 53,
Right.
should I only pay 100 or should I pay 18? Because I will have another 18 as ITC reversal.
Correct.
See, these are all questions for which there is no answer either in GST law or in IBC, where we have to make a list. As an IRP, I need to have a list. As soon as an assignment arrives, I have to send out circulars saying what I'm going to do with the monies customers are going to pay. I will undertake to remit the GST, or I request you to move an application to NCLT to get directions for this, because tomorrow some secured creditor might file an objection to remitting GST contrary to 53. In this PPT, I would have wanted to see a checklist of questions for which answers are there, questions for which answers are not there.
Yeah, it's a good point that now we will work on it, sir. I will talk to madam and definitely many things have come.
Madam,
everything 100% is madam only. Madam and Siddesh.
Madam, don't come under any pressure to somehow invent an answer to every question that comes up for consideration. The beauty of being a student is that I don't have to have all the answers. If I have all the questions, 90% of the battle is won. And in IRP especially, we have to move multiple applications. NCLT job is not very easy.
Okay, sir, we want your final thoughts on, like, when I said section 14 moratorium, department cannot file an appeal or continue the appeal proceedings. I said that an application has to be made to NCLT. So we want to know your final views on what the department should do.
Not my final views.
Okay, so the department is likely to continue and it will be left to the resolution professional to move an application before NCLT.
Department will continue, pass order. Once order is passed, the money will be written off by Department of Revenue, saying that only so much we will get from the proceeding. Now order is concluded. They can't keep all cases in call book indefinitely. They will pass an order, confirm the demand, then write off the demand.
So practically, are they continuing with adjudication as well as appeal proceedings even during CIRP moratorium period?
During moratorium, they are not. They are keeping matters pending. But in their system, they have to conclude all cases. So once either CIRP decision is taken or liquidation decision is taken, they will not abandon it. They will pass an order, quantify the demand, then write off the demand. See, we should do some case study analysis. You see, Kingfisher Airlines here in Bangalore only, all the Kingfisher properties, all the Kingfisher buildings, etc., how it has had taken place. If you start trace those cases, you will get a good idea how this will operate.
Another question for which I could not get an answer is Section 14 moratorium. There is a prohibition on initiation as well as continuation of suit or proceeding. And the moratorium, CIRP moratorium ends when either a resolution plan is approved or when a liquidation order is passed. If the corporate debtor from CIRP, if he is going to liquidation, now again at the start of the liquidation, you have to submit your claim. Liquidation also has a moratorium prohibiting initiation of suit or legal proceeding. So whatever adjudication or appeal proceedings which could not be carried out during CIRP, even if we say moratorium under liquidation, you can continue. What is the time period which is actually available to them to continue, quantify the demand and file it with the liquidator? Because once there is no resolution plan or the CIRP period ends, liquidation order is passed and liquidation process commences. So within 5 days, the liquidator issues a public announcement also to submit the claim within 30 days. If the proceedings are not, again, the claim is as on the date of commencement of liquidation. So what is the outcome of proceedings which are continued during liquidation? What happens to the demands that are quantified? Will it also become part of the liquidation claim? Will the resolution professional make a provision for contingent claims?
No new claims on liquidation. You see section 50 and all those provisions, right off. It will get extinguished. That is what was said in the Edelweiss. Entire cabinet.
Sir, you said something? Hello?
Yes, sir.
You said something, sir?
No, I was saying that that's what the liquidation proceedings. See, the purpose of those proceedings continuing, I feel, madam, is to conclude under the specific law all open matters. But once it comes to recovery, they have to get extinguished. That is what was said in Edelweiss.
Okay, got it. Thank you, sir. With that, I have come to the end of my presentation.
Madam, one question.
Yes,
If we
sir.
can make a list of judgments that we have referred, how many judgments you respectfully disagree? As students, we should have some disagreement about a judgment. If we don't have a disagreement with any decision, then we have stopped thinking. Which are the judgments where you disagree with?
Rainbow papers. The first thing that comes to my mind.
No.
No, sir.
Okay, no, okay. No, if we need to have a list, we need to have a reason why we are disagreeing with it, because it is not that that judgment is baseless. To read the judgment, who Indira Banerjee, no, very without too much of fluff, she has gone about to render the judgment.
And another judgment is a Supreme Court in Paschimmanchal, Vidyut and Raman Ispat, where they were questioning rainbow papers. But their own decision, I have a disagreement.
So it's necessary for us to have that part also in our Tuesday morning discussion, saying what about that decision? If the outcome is not to our liking, is not the reason to disagree with it. If the outcome is not according to our interpretation of the same statutory provision, can we appoint? Because tomorrow, what if there is a decision that is rendered overturning these judgments? Then will our views expressed so far will become outdated?
Yes, sir.
So if that also can, we can make a list. Whatever reason, satisfied, not satisfied for these reasons, with an alternative saying that this could have been rendered like this. Any idea on why, how else rainbow paper could have been rendered?
So the main question that I had was, by operation of law, can you say a security interest has been created?
Yes, possible. So many cases are there. What happened to Mada versus Sale? We discussed at length. By operation of law only, rights are created.
Security interest as defined in IBC?
Sorry. No, security interest recognized in IBC. It's not that IBC is creating a new security interest.
Hmm.
Is it a security interest that is recognized here? That's all. Books of accounts don't decide fixed asset. If it is an asset, books of accounts record it.
Yes. Got it, sir.
So, checklist of use cases, answered, not answered, and decisions that have differences of views from students.
Okay. Okay, sir. I had to have a slide on the questions for which there are no answers, and also the list of decisions, and whether we have a difference of view on that decision and the reason. Okay,
That's
sir.
all.
Okay, sir. Venu, can we conclude the session?
Yes, madam. So thank you, and thank you, Jatin sir, for the inputs, and we'll conclude the day, madam.
Thank you.
Thank you.
Thank you, Bhuvneshwari. Thank you, sir.
Thank you so much.